AD of 5 minutes. 6 seconds. 7 minutes. Second slide. Third. Fourth. Fifth. Sixth. Seventh. Eighth. Ninth. 10th. 5. 21 minutes. Awesome. So it is button normal. इधर सर इधर डाउन सर हाँ पेज अप करना है सर पेज अप पेज सर इधे पाई की सर इधे क्या इधे पाई का हाँ सर ओपन हाँ पाई की सर आज पकड़ के क्या लग क्या लगा हाँ
Yeah, please. Yes. Already we have enjoyed some 3-4 days of holidays. You have become lethargic, right? Yes. Right? We are saying award, right? Once award has been passed, what happens? It concludes the dispute as the specific issue determined in the award, so that it has residually effect between the parties. Once an award has been passed, what is going to happen? The dispute has been settled by the arbitrator. Dispute on the arbitrator settled on then it is having residual effect means once parties come to the arbitration, right? And it has been the dispute has been settled conclusively. That means every claim, whatever it was putting forth before the arbitrator, it has to be settled. Then the residual effect comes into existence. You cannot challenge the same claim in civil courts or wherever you want to go. This is first. Right. If it is a final award, it terminates the tribunal's jurisdiction. Once an award has been passed, award pass panna. This is not so in the case of normal courts. For example, court pronounces a decree and judgment. Once court pronounces decree and judgment, its jurisdiction is still there unless and until it has been extinguished by an administrative order, right? But whereas in arbitral tribunal, once the arbitrator passes an award, ఏమవుతుంది అంటే అతని jurisdiction ఏమవుతుంది end అయిపోతుంది. There is no review provision, there is no reference or whatever it may be, it becomes conclusive. Then it disposes of parties' respective claims. Whatever the claims you are putting before the arbitrator, they are going to what is called adjudicate your claims. Then may be confirmed by recognition and enforcement. Recognition is different, enforcement is different. That means when parties is recognizing the award, that means it is confirmed. When parties is recognizing the award, అంటే నువ్వు అవార్డు రికగ్నైజ్ చేస్తున్నావు అంటే మీనింగ్ ఏంటి? That adjudication has been confirmed by the parties. Or if the parties don't accept for this recognition, enforcement will be there. Why? Arbitral award is a deemed decree. Right? You can go to the district courts, you can go to the courts having jurisdiction, you can go and file the award for enforcement. Execution petition, you can go and file. Next one may be challenged in the courts of the place of arbitration. Here, jurisdiction of the place of arbitration can be chosen by the parties, but jurisdiction of the courts cannot be chosen by the parties. Once, if an arbitral tribunal has been disputed, where it has been passed, that the court will have jurisdiction. For example, Tirupati dispute related, you are choosing the arbitration in Chennai, award has been passed in Chennai, again, you cannot come back to Tirupati for challenging the award. Why? Place of arbitration, seat of arbitration is important. So, where the arbitral award has been passed, then that court is having the jurisdiction to entertain the challenge under section 30 or 34. Right. Now we have seen the Arbitration Conciliation Act does not define the term award. It says award includes interim award also. Previously, under the Arbitration Act 1940, there is no interim award is there. There is no definition of interim award. But the new act says arbitral award includes interim award also. That means at any point of time, interim awards can also be challenged in the courts. Like preliminary decree, you are going for appeal. Likewise, interim awards also you can go and challenge in the courts. That means interim award that does not finally what is called solve the disputes. Let's see. The Arbitration Conciliation Act does not provide a definition of award except stating that arbitral award includes an interim awards. So, different types of awards an arbitrator can make. So, these are the types of awards. The Arbitration Conciliation Act envisages the following fundamental types of awards. So, final award, interim or partial award, additional award, consent award, or it is also known as agreed award. Then default award is there. Let's go one by one. Different types of awards the arbitrator can pass. Different types, decree, judgment, final, appeal, so on so provision. Likewise, numerous awards can be passed by the arbitrator. Right? We will see. First one is final award. Right. The term final award is used to denote two different situations. Right. First one is when an award is final. When an award is final, what happens? Two things will happen. One is it will settle your disputes. Second one is it eliminates the mandate of the arbitral tribunal. ఒక అవార్డు పాస్ అయింది అది ఫైనల్ అంటే two technical things will happen. One is it conclusively determine your claims. I am not telling about rights. You understand? Claims were rights were. Arbitrator cannot determine your rights. You understand? Only courts can determine your rights. You understand? There is a difference between claims and rights. Fundamental rights, High Court and Supreme Court, legal rights, High Court and Supreme Court, civil rights, so many rights will be there. Arbitrator cannot what is called adjudicate your rights, he can adjudicate only your claims. And you are having certain claim between the parties. He is going to adjudicate only the claims but not the rights. If you want to fulfill your rights, you have to approach the normal courts. So two things. First, the term final is used to describe the award, which is final determination of all parts of the dispute, which was part of the term of the mandate of the tribunal with a binding effect of the parties. Right. Now, an award is final in this sense if it produces res judicata effect between the parties, right, and can be challenged or enforced necessarily terminating the complete arbitration proceedings. First, it is conclusively determining your rights. Second one is the entire mandate of the arbitration will comes to an end. Next one is it is having a binding effect of res judicata effect between the parties. Second, it refers to an award which makes the end of the proceedings and settles all the claims of the parties. ஒருவாட்டி arbitral award pass பண்ணா ரெண்டு இருக்கும். First one என்ன இருக்கும்னா res judicata effect இருக்கும். இதே dispute மேல நீங்க சிவில் கோர்ட்டுக்கு போய் திருப்பியும் suit file பண்ண முடியாது. First aspect. Second aspect என்னன்னா ஒரு வாட்டி அவார்டு பாஸ் பண்ணா மட்டும் ஆர்பிட்ரல் ட்ரிபியூனலோட ஜூரிஸ்டிக்ஷன் என்ன ஆகும்னா என் கம்ப்ளீட் ஆயிடும். அப்புறம் ஆர்பிட்ரேட்டருக்கு திருப்பியும் அந்த அவார்டை ரீஓபன் பண்ற பவர் இருக்காது. ஃபார் எக்ஸாம்பிள் கோர்ட்ஸ் கேன் ரீஓபன் தி ஜட்ஜ்மென்ட் பை வே ஆஃப் review. Courts can again review the judgments, but once an arbitral award has been passed, you don't have any power to review the judgment of the what is called arbitral award, except few typing errors or clerical errors only. அவ்வளவுதான். திருப்பியும் ஒரு வாட்டி கிளைம் மொத்தம் பார்த்து புது அவார்டு பாஸ் பண்ண சொன்னா ஆர்பிட்ரேட்டருக்கு பவர் கிடையாது. The power of the arbitrator is conferred by the consent of the parties. Power of the review cannot be conferred by the parties. This we have to observe. Again, మళ్ళీ సివిల్ కోర్టుకు వెళ్ళి సేమ్ డిస్ప్యూట్ సూట్ ఫైల్ చేస్తామంటే కుదరదు. ఎస్టికేట్ ఎఫెక్ట్ వచ్చేస్తుంది అక్కడ. Everything will comes by your consent only. That's it. You are consenting for arbitration. You are telling that the arbitral award is final. It is binding. You have to, for example, contract act. Court never asks you to come to the courts. You are signing the agreement. You are accepting that your legal obligations are submitted to the courts. Likewise, also you are going before nobody is asking you to go for arbitration. You are allowing yourself to go before the arbitration. You are telling that award is final. You are telling that award is binding on you. Right. So final award has two things. Terminate the mandate of the arbitral tribunal. It settles the claims conclusively, and once it has been made, res judicata effect comes into existence. This is final award. Right. Now we are going to deal with interim or partial awards. Again, arbitrator is empowered to pass interim or partial awards. Interim means in the middle of the final award. It don't conclusively determines your claims. Right. So parts of the claims submitted to the tribunal may be appropriate for resolving at an earlier stage, while other issues require further submissions and assessment. Likewise, preliminary decree is there. Here also, arbitrator is empowered to pass certain interim measures in the form of an award. So whenever arbitrator feels that he has to pass some interim measures, he may pass partial awards or interim awards. The partial or interim award may be a precondition to deciding whether the arbitration should continue to a further stage. That means, preliminarily, you are raising certain issues. Right. Now, unless and until that issues have been solved, you cannot proceed with the further. For example, if you want to go and file a case in Supreme Court, SLP is there, special leave petition. Unless and until SLP has been determined by the court, it cannot go with your case. Supreme Court will you, whatever be the case you are filing in the Supreme Court, they don't take your case. You know, Supreme Court in the case file for Supreme Court, you should accompany with one petition, that is, you are asking the leave of the court. So, special leave petition will be there. Your petition will be there. Unless and until it is determined, they cannot go into this case. It has been dismissed. Your special leave petition, they don't even go with this case. Supreme Court SLP file பண்ணும்போது ஒரு petition file பண்ணனும். நீங்க எந்த கேஸ் இருந்தாலும் Supreme Court போனா Supreme Court எடுக்காது. Simply understand. Even you go under Article 32 also, Supreme Court never entertains your case, but it's not your right. First you have to ask the leave of the court, special leave petition. Right? I am seeking the leave of the court to go into my case. This is has been dismissed. In the case வராதீங்க எங்க போறோம் அப்புறம் வீட்டுக்கு வரணும் அவ்வளவுதான். You have to come to the home only if your special leave petition has been admitted, then they will give a further hearing for this case. You understand technicalities. Likewise also, arbitrator has to first pass an award interimly so that he can decide the disputes finally. Right. So it's a precondition to deciding whether the arbitration should continue to a further stage. Example you see, if there is an issue whether a claim is statute barred. You understand the meaning of statute barred? புரியுதா? Statute என்ன? What is the meaning of statute? Interpretation of statutes. ஒண்ணுதா இல்லையா? எந்த செமிஸ்டர்ல வந்து எந்த statute என்ன? What is meant by statute? What is meant by charter? Charter. Clear? Charter and statute and statute means act. In India, we are calling as statute. In England, it is called as charter. Chartered standard banks will be there. You understand? Right? Statute barred. That means you know the meaning of time barred debt. Time barred debt and what is the meaning of time barred debt? Right. Time what? According to what time has last? Very good. Limitation Act 1963. There is one act is there. For everything, the law of limitation act 1963 will apply. Again, arbitration conciliation act is a special act. The time mentioned in the Arbitration Conciliation Act, two things was like, you have to understand technicalities. One, before starting of Arbitration Conciliation Act, once proceeding has started, the law of limitation won't apply to arbitration. You know, arbitration very specific time limit is there. Before filing the case in the arbitration, limitation act will apply. Once your what is called application has been admitted by the arbitrator, then the time limit prescribed in the arbitration conciliation act will apply, but not law of limitation. అర్థమవుతుందా? అక్కడ చెప్పిన టైం అప్లై అవుతుంది కానీ లా ఆఫ్ లిమిటేషన్ చెప్పిన టైం అప్లై కాదు. Why? This is a special act bypass for the law of limitation act 1963. Right. Now, whether the claim itself is a statute barred, that is, for example, limitation act 1963 said, you know, different schedules will be there in the limitation. You cannot sleep over your rights for a long time. For everything, there is a prescribed time will be there in the limitation act. Now the question is, before the arbitrator, one person is raising a dispute that this is time barred. You cannot adjudicate upon this dispute. You understand? Time barred అయిపోయింది. ఇక్కడ dispute adjudicate చేయడానికి రాకూడదు. Even though you are having a right, it cannot be settled by the courts. You understand? For example, provisionalization now is there. Within 3 years, we have to go and invoke the suits. If after 3 years, if you go to the court, no doubt you are having a right, but you are losing that right by way of limitation. The current கொடுத்தது கரெக்ட் தான். கோர்ட் வர முடியாது, ஏன் வர முடியாது? Time has been expired. Now the issue before the arbitrator is whether whether the claim is statute barred or not. Unless and until he adjudicates that thing, he cannot go into the final adjudication. First, he has to pass an award on this interim dispute. First, time barring the dispute chasing taravate, he has to go for the final things. So, if there is an issue whether the claim is a statute barred, the parties can agree that tribunal determines a specific issue by entering an interim award. So unless and until there is a ruling on the interim award, it cannot go into the veracity of the claim that has been made in the final issues. Right? Such interim award will be a ruling. That means it's only it's a sort of decision. For example, on issues of jurisdiction, whether the arbitrator has jurisdiction or not. Unless and until he resolves that thing, he cannot go into the main issues. Next one, applicable law. Right? Liability or qualification of damages. Qualification of damages. These are on these aspects. The arbitral tribunal can pass them interim award. Right? In the absence of an agreement, the tribunal may still render an interim award. Such interim award will be a ruling, for example, on issues of jurisdiction, applicable law, liability, quantification of damages, liquidated damages, unliquidated damages. He can give. Again, whatever comes to his mind, he cannot give. He has to work under the act only. Everything, Arbitration Conciliation Act, public policy, general laws, Constitution of India, everything he has to follow. In the absence of an agreement, the tribunal may still render an interim award if it considers that it is appropriate in the circumstances of the case. Right? So, the arbitral tribunal is empowered to pass interim or partial award also. Partial award very pass చేస్తారు అంటే issues of jurisdiction, applicable law, liability, quantification of damages on this, they can cause an interim or partial award. Right. Third category of award is additional awards. Additional. That means it is in addition to the final award. We will see what it is. An additional award is normally available so that the tribunal can address issues which it failed to determine during the arbitration proceedings. For example, you go before the arbitrator, you put forth some five claims. Five claims regarding you. Due to inadvertence, arbitral tribunal has only adjudicated your four claims. Then, additionally, another fifth claim, it can cause an additional award which has to be read with part and parcel of the final awards. So, you are putting the five claims. The arbitrator is adjudicating only four claims. Subsequently, on fifth claim also, you have approached the arbitrator. He is passing an additional award. So, an additional award is normally available so that the tribunal can address issues which it failed to determine during the arbitration proceedings. According to section 33(5) of the Arbitration Conciliation Act, a party to arbitration within 30 days from the receipt of the final award within 30 days, time limit has been prescribed in the Arbitration Act. Here, once arbitral proceedings has been started, then law of limitation won't apply. Whatever we can mention in the Arbitration Conciliation Act is there, it has to follow the same. So a party to arbitration within 30 days from the receipt of the final award, they request the tribunal to make additional arbitral award so as to claims presented in the arbitral proceedings but omitted from the arbitral award. Once you receive the final award, if you feel that any claim which you put forth before the arbitrator that has not been decided by the arbitrator, you can see additional award which has to be read with part and parcel of the final awards. No, I am seeing your face, don't worry. I am seeing, I can remember your faces. When you come for a Viva, then you will see, you will be having Viva of his face, don't worry. Because if you even if you look into my eyes also, I don't look into your eyes. Simply I turn my face. புரியுதா? கிளாஸ் ஒபீடியன்ஸா இருக்கிறவங்களுக்கு ஒரு privilege இருக்கு. If you can ask your seniors, if you play something different, I will also play something different. ஒருவே சொல்லலனா கூட அனுப்புறேன். சொன்னா கூட then you will going to see. Whenever you come to the class, have some attitude. நான் தான் என்ஜாய் பண்ணணும் இல்லையா? இன்னைக்கு ஒரு நாள் கிளாஸ் கேளுங்க. Anyway, you are not listening for the exact 3 or 4 days. Listen something just going to the mind. Right? Basically, you are all people. Only thing is, you have to re-engineer your mind program. Re-engineer your mind program. That's it. Mind program என்ன இருக்கு? 3 வருஷமா ஒரு program என்ன இருக்கு? அதை erase பண்ணி new program fix பண்ணணும். அது ரொம்ப கஷ்டம். Once you start the program, once you start the program, slowly it will come. Right? Yes. Basically, another appreciable thing is, to some extent, you listen my class. Another appreciable aspect. Without a class, at least you are listening my class. Which class are no class? Right? Right. That's good thing. Right. Next one is consent award or agree award. Right. We will go into this. Salama. You are all matured. నా వైపు చూపించుకుంటే అది నీకు బాగా బాగుంటుంది. There is some sort of you have shown some maturity, right? Now, an award of creditor or consent award is the ruling of the tribunal which incorporates the settlement that the parties have reached during the arbitration. That means you yourselves have accepted for a settlement and the arbitrator passes an award, consent award. For example, consent decree is there. You go to the courts, but you have accepted for some time terms and conditions. On that terms and conditions only, the judge will pass a judgment. Arbitrator ఏం చేస్తున్నాడు adjudicate చేయక పూర్తిగా you are coming to an agreement. You are telling that yes, we have consent for this. Please pass an award. Now you can raise a question. When both parties are accepting for an agreement, why award has to be passed? అర్థమవుతుంది ఇద్దరు ఒప్పుకున్నారు part you are going telling that you are accepting for agreement and why award has to be passed. That means when award has been passed, it's a binding effect on you. Judge సంతకం పెట్టినారు అంటే వేరేలా ఉంటుంది. పార్టీ సంతకం పెడితే వేరేలా ఉంటుంది. For example, in a divorce case also, if an award has been passed subsequently, they cannot question the same. Here also the parties are accepting for an agreement. The arbitrator is passing an award. Once an award has been passed, it is having restricted consent. ఇప్పుడు ఈ యాక్సెప్ట్ పన్నె యాక్సెప్ట్ చేశారు మళ్ళీ నువ్వు ఏం చేస్తావు నువ్వు will go on by this civil courts. Yes. Yes. And the rest rest of it is very good. Now, the Arbitration Conciliation Act provides that it is not incompatible with an arbitration agreement for an arbitration tribunal. Here also, the section 30 says that you cannot what is called go for this settlement awards. When అలాగే వీటిలో తూమి ప్రాక్టీస్ అయ్యేది ఇంకా ఉన్న అదే అనుకున్నాం ఇట్లా అందరూ పోయి టైం ఎంత అయింది నైట్ వరకు ఎలా అనుకున్నాం నైట్ వాడెన్ no you have been disordered with sort of things sleeping in the house so automatically your biological clock starts. There is one clock in your body it is known as biological circadian rhythm అని చెప్తారు. ఆటోమేటిక్ గా వచ్చిన తర్వాత ఏమొస్తుందంటే నిద్ర వస్తుంది. నిద్ర నిద్రపోయి అలవాటు కాబట్టి when he came to the class he was very lean. Now he has become like this. Now all I am saying 5 years whoever joins in this college 5 years course they will be like lean. After completion of 5 years they will become like this. Yes, especially after students. Right. Accustomed to sleep in the afternoon. Right. So this section 30 never encourages that settlement award. You understand? Section 30 specifically states. Shivani, enough. The Arbitration Conciliation Act in Section 30 provides that it is not incompatible with an arbitration agreement for an arbitration tribunal to encourage settlement of the dispute and with the agreement of the parties. The arbitration tribunal may use mediation, conciliation, or other procedures at any time during the arbitral proceedings to encourage settlement. Right? Normally, it discourages the settlement procedure. Next one is Default award. Default award. Right. We will see what it means. A default award is an award made by the tribunal in proceedings where one party files to make an appearance. Right? If one party fails to go before the arbitral proceedings after accepting for the arbitration, the tribunal is empowered to make a default award. Default proceedings are acceptable under the or previously there is no default award. Under new act, the default award is recognized. Right. Now, time limits for making of an award. The entire premise on which area starts is time limit is there. Before civil course, time limit is there. Now we are going to see within how many within which time the arbitral award has to be made. It is generally expected that awards are made promptly. In the Arbitration Conciliation Act, the laws do not set time limits for making of an award. There is no prescribed time limit is there. It has left it to the discretion of the tribunal to determine the appropriate time for the rendering of an award. It is two reasons why the arbitral tribunal is unable to fix the time limit. It is difficult to fix a time limit for all types of cases, and a mechanism for the extension of time limit should also be put in place. Right. Again, if we extend the time limit, again legal consequences will come into picture. For normal course, there is different procedure. Arbitrator, different procedure will be there. So, secondly, it is difficult to agree as to what the legal consequences would be on expiry of a statutory or party agreed time limit. In normal course, if the time limit has been exceeded, there is a remedy for the persons. Now, it is not here in the Arbitration and Conciliation Act. That's why there is no prescribed time limit. The tribunal has to fix appropriate time limit. ఈ time limit లో అవార్డు పాస్ చేయకపోతే లీగల్ కాన్సిక్వెన్సెస్ ఏంటని చెప్పి చట్టంలో లేదు కాబట్టి the arbitral tribunal has to fix an appropriate time. Then communication of the award. According to section 31(5) of the Arbitration and Conciliation Act, after the arbitral award is made, a signed copy shall deliver to each party. Once an award has been made, it should be signed by each party as well as the arbitrator. Correction and interpretation of awards. The standing on the steps. It is sometimes necessary to correct obvious clerical, typographical, or computing errors in an award or to clarify some ambiguity. So, Arbitration Conciliation Act provides for correction of an award either on receipt of a request by the party within 30 days from the date of communication of the award or on its own initiative within 30 days from the date of the arbitral award. So, these are the different types of awards which can be passed by the arbitrator. Tomorrow we are going to see challenge of the arbitral award. Got something today? Right. Good morning, all. Please settle down. So last time we have all discussed about the roles, function, principle of policing, roles and functions of police, problems. That all we discussed last class. Now come to the criticisms. Okay, first criticism on the investigation. Till now, police investigation is based on how they are investigating pre-independence. That means third degree treatment to the offenders. Yes or no? Mostly our investigation is depend on that thing. Though our science and technologies are more developed, but still, okay, what you see, what you find out, confess the crime. That's the system of policing. That means there is a massive essence of massive use of the scientific procedure in the criminal investigation. What you are mostly see in the other countries, that is essence in India. Police are still now are not that much give importance to the science and technology. Second one, why discretionary power is given to the police? They become the mind of everyone. That means whatever they told, they have the power to manipulate in the legal system. If you argue with the police, you have a fear that they can put you in a false charges because they have the discretion. Because it is a false charge or true charge, it is take time to prove in the court. Yes or no? Simple if it is a 323 case, simple one case, that may convert into 327 or 325. So it takes time to prove it. No, it is not 325, it is 327. Wide range of discretionary power and other mechanisms. Same again during the investigation, extra legal methods. Extra legal methods that Rohit said it will what happened by the police. Yes or no? But you guys are not film guys. Or in this South Indian films, if Rajnikant wants someone, he so that methods are still used in the by the police, which is an extra legal. Because if you go to that Sunil Batra versus NCR Delhi, DK Vasu case, whatever the cases you can find out there, this inhuman tortures, inhuman treatments by the police to the arrestee is prohibited, but still they are using that preventive measures taken by the police affects becomes very harsh. Yes or no? Delay by the police in reaching the spot in occurrence disorder situations. In our time, I don't know that you have thought about that joke or not. Why the police general number is 100? Because you call 100 times they won't reach. Nowadays. But sometime before, some later before, it is the general joke. Why it is 100? Now by calling 100 times also they are not. So डिले इन रीचिंग, कहाँ जाएंगे, देखेंगे, सोचेंगे, क्रिमिनल लॉ. Last one, image of police among the general public is so ugly that government does not come forward to render any cooperation with it. Last class I told you, we feel very much anxiety and all and nervousness before a police rather than an enemy, which must be opposite. If there is a police, we may feel safe there, but we feel very uncomfortable if a police is there. Why? Because they made their request like that. So general public, why we should go to the police? That is the only reason why general public didn't like to cooperate with the police. Because only of that reason. That image of the police, how they made it. So these are some criticisms for the police. Next one, causes of failure of the police. Same whatever we are discussed is a problem of the police, criticism to the police. That are the failures of the police. Same thing, misuse of power, oppressive policy, corruption, shortage of staff, lack of cooperation by the public, political interference, non-technical police forces, lack of proper training, and at last, police are also humans. गलती इंसानों से ही होता है. So these are some failures which are there. We already discussed most of these things in the this problems, criticisms. We already discussed this misuse of how they are misusing the power, oppressive, overusing of the powers, corruptions. If it is a hit and run case, take 5,000. Don't know, don't remember, no eyewitness. Finish. Shortage of staffs. An example of this Tirupati. Tirupati's population is nearly 50,000 to 100. More? Okay, 3 lakhs. How many police are there? So for at least for 1,000 people or 10,000 people, one police is not there. How there the control is happening? You know it better. Lack of shortage of laboratories. Advance of the investigation. Nothing is there. Where is the forensic lab here in Andhra Pradesh? Vijayawada. So for simple DNA testing also, the police has to send the sample to Vijayawada. Simple. That this blood which is found out in the crime scene is matched with that particular person is same or not. You have to send it to Vijayawada, Vijayawada send it again. So political interference, IMNA, that is my limit. So like that, these are the failure of the police in India. Duties. Duties, you can find out some duties are given in the Police Act, Indian Police Act 1861, and some others, or mostly similar kind of duties are given in the CRPC also. Mostly in CRPC it is given regarding the investigation, and in Police Act the other general duties are discussed in that part only. So what is the duties? If you go to section 23, police officers are promptly Good morning to all. So, an announcement for board observation classes. So, who are posted for 23rd? Session is postponed due to the Saturday. The group of 5-year DBA register number 520-1061-1098 and BCom 520-2001 and up to 2010. These students we have now code observation. Okay? So the 23rd morning session students, BBA and BCom students, now you have now today code observation classes. You can write room number 1 in 4th floor. We will take the attendance now. After attendance, we can do. So our BBA and BCom, the register number students, we can go now. 520-1061 and up to 98 BBA and BCom 520-2001 and 520-2010. Up to these 50 students, you can go to room number 1 in 4th floor. You have now got observation. And notice 23rd afternoon group BCom 520-2011 up to 520-2005 and your afternoon session code observation. So rest BCom students, you have today afternoon code observation. Yeah, this is clear also. Okay, understand? And next, 3 years general work schedule as per 26-3. 26-3 up to 3 years general 5-2-23-001 up to 15. You have tomorrow observation, tomorrow morning session. Okay? So 3 years general students 1 to 15 you have tomorrow morning session for observation is there. And afternoon session 30512 up to 100 you have tomorrow afternoon session for observation. Understand? And next 13 March for postponed for 3 general student afternoon batch. Sorry, 23 afternoon batch. That is for 5223 251 to 303. 251 to 522 303 who are for 5 years, sorry, 3 years general. The afternoon version we have posted for again third afternoon. This batch already visited, but due to the bar election, they not observed, right? What are that batch instruments in that? So we are posted for again third afternoon. Okay? Third afternoon. You have again you have to go for those. And 33 as last Saturday batch, we are posted for 3 years honors 1 to 50 third morning session. Okay? Third morning session and 51 to 100 third afternoon session. I clearly said the schedule. Everyone got? Don't say I don't know about this schedule. We can't give another chance. So now we can go for 5-year BA and become up to 10. Group number 4 we will take the attendance. And again telling the BBA rest of the BCom students you can come from today afternoon and general students, 3 years general students 1 to 50 you have session for tomorrow morning session and tomorrow afternoon session for 51 to 100 tomorrow afternoon session and 23 who are attended for afternoon batch you have for the third onwards afternoon session you have for your court observation visit is there And 13th batch you have a third from the morning and fourth afternoon session. As per register number wise, 1 to 50 morning session and 51 to 100 afternoon session. Any doubts? Yeah, language. How many RA students are there? RA students. Give me your numbers so I will discuss with the management. Please, those who are areas, please right now keep your roll numbers, sorry, registration number along with your name. Right now. How many are there? 4, 5? Right, this year, this last semester areas. Last semester areas, not the previous areas. Last sem areas. How people? Somebody have areas to be some name again. That people, I request you kindly report me. All are measures. All are measures now. Thank you. Fine. Now listen. Please settle down. So now what is the duties of a police officers according to the so what duty to obey and execute the order from the legal authority. That means whatever the orders are given by the court, that is to be executed because as we already know, court give their judgment, but execution duties remain only with the police. Court cannot execute the order given by him. It is not his duty. He can say that okay, this Mr. X has to go to the judicial custody for 15 days, or after the completion of the case, he can give the judgment. Okay, he has to spend 3 years as a punishment for particular offense. Judgment is given, but who is going to execute it? It is the duty of the police. Second, prevention of any crime which is going to be happened or any public nuisance which is happening during that particular time. Third, to detect the criminal and to bring him to the justice. That means after commission, because they like once the judgment is given, it is the duty of the police to execute it. Now, when a person committed a crime, it is also the duty of the police officer to bring it before the justice. That means to bring the court. In section 35 of CRPC, I think this thing is discussed. Section 30 or 30. Right. Last one, police officer for any purpose to raid, to seize, to confiscate, search, anything, they can enter to a drinking shop. That means here it called as tourist shop, right? Drinking shop, bar, drinking bar. They can enter there, gaming house and other places, resort of the loose and disorderly characters. They can enter there with or without a warrant, can go for there to search, seizure, confiscate, and all of sort of that things in that particular places. That means mostly your gambling houses, toy shops, and all other sort of things where there is a chance of the disorderness in the society. Next one, section 24 of that same act, to give the information to the court. That means to whom you arrested, what is your progress in particular investigation, what is the your record, that means you completed it or not. All the information should be given to the concerned magistrate. As a police officer, in CRPC also it is told that if you are arresting a person within 24 hours, you have to produce it before the court. Section 57. 57. 57. So, like that, that means he is giving the information to the police that I am arresting this particular person. He is producing his CD, PL diary. Okay, this is my uh, procedure of investigation of how I enter an investigation. After completion of investigation, police report is given. Final form or last form, whatever you call it. Charge sheet. It is submitted to the court. Then okay, this is the investigation. This is what I get it in the conclusion. That means all the information regarding the criminality or criminal society or criminal investigation is given to the court. Next one, two, police officer to take charge of the unclaimed property and to be the subject to the magistrate's order as to disposal. That Mr. X here he is presented. He is the dealer of the opium. Once it is cut by the police, seized by the police, does he go and ask, no, that whole consignment is belongs to me? No, no, can't understand. Okay, I am a drug dealer. Okay, I am a drug dealer. And one of my consignment was seized by the police. In that case, should I go to the police and ask, so that particular consignment is belongs to me? That means it becomes an unclaimed property. Same way in some tourist destinations or railway stations in some areas, you can find out the unclaimed properties. So who is the becomes the owner of that one? Police is it. Government, mostly police. Government is not that your chief minister or home minister, they don't come to seize one. Police officers come and seize that particular property. And according to the order of the court, they can deal with that property. In section 467 or something, the disposal of the properties in CRPC, there is under that particular section. Same thing is said in these two sections also. How the magistrate may retain the property issued for the proclamation. Which section that is? Procedure of disposal of the property in CRPC 460 456. Procedure of disposal of property. That thing you can relate here also. Once police is seized that property, then it goes to the court. How the court deal accordingly, and after the order of the court, 452, starting from 452. So that's all that means. What is the penalty for the police officer if they neglect from their duty? In IPC, mostly 161, 162, you can find out that particular provision, what is the punishments are there. In Police Act also, there are some other general rules are given which should be followed by the police. If they don't follow that particular rule or procedure enumerated here, then what is the penalties that is described in this particular case section 29? What are the circumstances where that particular person is going to get the punishment? First one, if a police officer willfully breach his duty or neglect any rule, regulation, or order given by the court. First circumstances. Second, abscond from his duty. That means without any permission, he took the leave and go. Most of the time, you can find out in papers there is a public announcement. Sipahi name X, their number, police number this, has to be ordered to present himself before the barrack manager, before Ustad, in Hindi is Ustad, on such that otherwise a legal, sorry, disciplinary action is taken against him. In papers you might find out this type of cuttings. Yes or no? Newspaper. आपको हिदायत दी जा रही है कि आपको उस्ताद के सामने इस पर्टिकुलर डेट में आके उपस्थित होना है. Yes. Yes, like that. Otherwise, it is disciplinary action is taken against you. This is the disciplinary action under this section. Next one, that particular police officer is a police officer. Why he is a police officer? He is dealing with other businesses like advocates. You guys, you registered yourself as an advocate. Yes or no? After completion of this thing, you become an advocate. After registering yourself. In one place you register yourself, then you go for a government job and other thing without what you call it, properly giving the information to the bar or council of your particular state. In that case, it comes under your professional, comes against your professionalism. In Advocates Act is written down there. When you are practicing as an advocate, you cannot involve yourself in any other businesses, services, and like that. Same thing applied here. If a person is a police officer, he cannot deal for any other businesses or services. So if he do like that, he get like not exceeding 3 months fine or both of imprisonment. Clear? Yes. Imprisonment, na? Once imprisonment is clear, everything is cut off. Alarm says in your silence is everything stop. Police act. Oh, sorry, applicable to volunteer. Mostly it is a concurrent list, covered up concurrent list. State list. In that case, law is concurrent list. It depends. Law is concurrent list. It can be taken by the union and state. And done by the state. Sorry, union. It is at that moment it is law. Or but if the state wants to amend that particular law, in that case it should not be derogate or violate the law prescribed by the union. Since when? Before 1861? Look, I'm telling about investigation in my case. Okay. The charges should be filed within how many days? If it is a non-payable offense, 90 days. 167. 90 days. Our state amendment, it says 120 days. So like that, if there is a law which is made by the union, state can make their own law, but the problem, the condition is it should not be derogate to that. Sending. That's all. Not discussed. Okay. Next class we will discuss. Policing is over. Next class we are going to discuss the important duty of the police, that is arrest. पुलिस क्या करता है? अरेस्ट ही करता है ना. So what is arrest? What is the procedure of arrest? Guidelines given in different case laws. Rules of arrest that we are going, and types of arrested persons that we are going to discuss in the next class. Please go through it. Already you read it in your CRPC. Still again please read it and come to the class. So here the class is over now. There is an announcement regarding the Moot court competition which is going to be held in 15 and 16. Good morning, all. So, there's an announcement regarding the conference competition. Okay. So, those who are here, then info participation. So, here I have a list, and it's in the final stage. Okay. So, I will call one person, like speaker one from each team. So, they have to come forward and they have to confirm. Okay. Regarding other members. The team. Okay. So, and you know the team called? So there is a team code for that. Okay, so every team does a team code. So the team code is like MC101. So I will call speaker one for that day. That's Mohammed Faisal A. Please come forward. Mohammed Faisal A. The speaker to Mohammed Das. Not here.
Mohandas. Okay. The researcher Ll.B. Ll.B.
Okay.
Regarding team presidency, 102, speak about face Chalishma, not here. Then Tanuja, Krista. Regarding Innovative Presidency, what's your team? Himani, speak about Himani. So I will confirm you can stand there. And second one speaker Maheshwari and Anshia. Confirm. Okay. Then MC Kasra for Rekha. Speaker one Rekha. Okay. Then Arya. Yes. Then Arvind. Arvind. Please Arvind. Arvind. The concept of part is Avnish Bharat. Avnish Bharat is not here. Satya. 106. Deveshwari. Sheikh Javed. Sheikh Javed. Madhukar Ali. Madhukar Ali. Kumail Sheikh. Kumail Sheikh. Kumail Sheikh. Gokul.
Humayun Sheikh, Hirendaran, Y.E. Gokul. These are the things you have to coordinate among yourself. Stacey Wilson, Billy Davis, Duster J. Verma. You have to coordinate among yourself. PM Chandra, Navin Karan, Harikaran. P Harikaran. Chandra, Navin Karan, P Harikaran. You have to coordinate among yourself. Victor, P Vijay, P Kamil Selva. Please be silent. Victor, Santa Vijay, P Kamil Selva. Jyoti Rasuka, Vinay, Jose Copy. Jyoti Rasuka, Vinay, Jose Copy. Yadu Krishnan is A. Prasad, A. Reddy Sai Sandeep. You have to. Next one please. Harivaran, Sanmuga Sundaram, Venkata Subareddy. All you guys are in team. Please coordinate among yourself. Yes. Sanmuga Sundaram, Venkata Subareddy. Sanmuga Sundaram, Sanmuga Sundaram. Yes, Kiran, Manish, SS, Amasha. B. Kodan Aswati Narayan, Dikta Kampuri. भुवनेश्वरी कृष्ण भुवनेश्वरी कृष्ण युगसंख्या ईशा हुसैन निशात हुसैन निशात हुसैन सत्यवानी शर्मा धनश्री दर्शनाश्री शर्मा एस कार्तिक एन तानिक तामिल सेल्वम योगेश्वरन and these those who are registered their name for the Venkata Subbarayan Venkata Subbarayan Dinta Babu Moreling right Honey mother, please. the universe and let us confirm.
Right, water. Extra service. Yeah. ఇంత కాలం ఉంది కదా దీనికైనా కోటికి ಅಲ್ಲಿ ನಾನು ಸಂಘ ಬಂದ 10 years ఖర్చు పెట్టాను ఈజీ రాయల్ ఈజీ ఏది లేక ఫెయిల్ ఏమైంది రాకేష్ వేర్ లాగిన్ పడ్డా ఇష్యూస్ క్లాస్ లేదు మ్యామ్ అయిపోదాం నేను అందుకే ఆగున్నాను గడిలో కూడా అయిపోతాను తొందరగా చెప్తాను వేస్ట్ 50 ఉన్నా పెట్టేశాను ఓకేనా మ్యామ్ ఈ పైన ఇది ఒకటే పని చేయదు ఇదంతా పని చేయదు అక్కడ మార్చుకోండి
And so, the previous class, we are saying accountancy for lawyers, because lawyers have basic knowledge of the system, accounting system, how to manage day-to-day expenses, income, and all. So, in conclusion to that, we will see the rules, the law frame even by the bar council of India regarding the maintenance of accounts by an advocate. No photos. And the rules that are made are seen from rules 25 to 32. So 25 to 32. How many rules are there? 8 20, 8 rules. All the rules are, you might have come across all these rules in our previous lectures and all. You just observe what a specific rule says. That's all. You will get one definite question from accountancy. So please concentrate. Just note down the important points. That's it. You need not write an answer, just get an expert. Coming to rule 25. Note down. You have started noting. You can if you want. So rule 25. An advocate should keep the records, accounts of the client's money entrusted to them. Is it not the duty of an advocate? So, all these rules are already seen in the duties. Duty of an advocate towards the client. This is just like a recollection. So, an advocate should keep the accounts of the client's money entrusted to them. He is responsible. He is answerable to the client. Whenever client demands, he must be in a position to show the details of expenses. Next, rule number 26. The money received from the client must be entered and it must be specified to which account it is spent for. Account received for the expenses shall not be diverted towards appendix fee without the consent of client. Client is over 50,000 and later on we fail to pay the fees or whatever the applicant demands or requests or whatever it is. And so, can an applicant adjust the amount which he has, which he is in possession of, towards the applicant's fee, to recover the amount and adjust no. That is different, and this is different, and cannot be mingled at all. The amounts must be kept separately. The accounts need to be maintained separately, and the amount cannot be used for the other without the consent of the client. And next, 27. Where any amount is received on behalf of the client, the fact of such receipt must be intimated to the client as early as possible. Applicant is bound to inform the client each and every information regarding the fees, the amount he received on behalf of the client. Client cannot this should not be the attitude of an applicant. Okay. Next, rule 28. After completion of the proceedings, the applicant shall be at liberty to take the settled fee due to him towards the unspent money in his hand. Whatever the amount, in my previous example, I told you that 30,000 or 50,000 just to the applicant. So if the client fails to pay the fees and all, and he can take the due whatever he gets, he should get from a client, and the remaining amount must be returned to him. There are advocates who charge money. There are advocates. There are. So, kindly don't involve in such degrading situations. But Mother's Chakravarti, what do you do? You are a live example if you are already. We have done a live example. Okay. And so, rule 29. Rule 29. Just follow the rules. You must be aware of all these rules and rule 29. After taking the fee, the balance should be returned to the client. That cannot be put in the pocket. In the lab, money pocket as well. And rule number 30. Post session, post lecture, okay, we have a detailed discussion on it. You are not very happy. So, for your friends, okay. And rule 30. A copy of client's account should be furnished to them after getting the necessary copy charges also. Xerox copy. See, there are advocates who are very liberal. Very liberal. They don't charge, they don't mind collecting penny expenses and all. Free of messages and all of that. But in contrast, we see advocates who charge and they are not ready to lose even a single paise for the client. So, so have some passion. Okay, clients together are national కొంచెం దయగా చెప్పుకోవాలి. Rule 31. An advocate shall not make any arguments whereby the client's funds in his hands are converted into loans. Rule 32. An advocate shall not lend money to his client for the purpose of conducting the case. ఏ రూల్ చెప్తా వేరే పనే కాదు. And coming to the rules that are relating to accountancy, which are specified even under the IT Act. IT Act rules are clearly marked here. Key rules for standard computing. What change in these rules? Again, rules are marked. Yes. So, as per Income Tax Act, as per the Act, an advocate is bound to maintain certain books of accounts. All these are given here. You might have seen that many of you are in practice also, and no doubt in that. But those who are not aware of this and those who stay away from maths or economics side, వాళ్ళకి కొత్తగా ఉంటుంది కాబట్టి ఇంకొక ఆన్సర్ and the books that are to be maintained by an advocate, a lawyer, are cash book, receipt voucher, payment voucher, journal, ledger. What is cash book? It contains all the details of amount received and the amount spent. Amount received and amount spent. That is cash book. So, at the end of the day, an advocate can have the photos, background music, next, receipt voucher. What is this receipt voucher? ఏ ఒక ఆఫీస్ ఎస్టాబ్లిష్మెంట్ ఏ ఒక ఎస్టాబ్లిష్మెంట్ తీసుకున్నప్పుడు వాచెస్ అనేది ఒక మెయింటెనెన్స్ రిసిప్ట్స్ receipt voucher. Advocate shall maintain receipt books with serially numbered receipts. Serial numbers. Original is given to the client and the duplicate with the advocate for future reference receipt. And next payment voucher. The same for post fees, stamp fee, stamp contribution or application. How much advocate charge? Stamp fee or fee, one thing. 100. So, you should have a legitimate claim on the amount from your client. Announcement will burden your clients. Okay? For your living. Next, journal. What journal means? Journal. Hello. Contains the details of the amount received. And based on this journal, a ledger is prepared. Journal is just for ledger. So ledger prepared చేయాలంటే I think your accountant he prepares. So you must be in a position to provide him the journal entries. And this journal, it is called a first entry, book of first entry, and the transactions are recorded date-wise. Whatever the amount that the company spent or received from the client, everything is maintained in journal, and this acts as a base to prepare the ledger. Ledger లో we have separate accounts. అవునా? So అన్ని accounts మనం prepare చేయాలంటే information ఉండాలి. That information we get from the journal. This is ledger. It contains there is in ledger different amounts are being created and accordingly the amount is transferred. Amount will be mentioned in the statements. Last rows. And so this is with regard to accountancy purposes. I ask the last two rows to maintain silence. What should we do next? We won't need to repeat any topics. We won't need to repeat any topics because today we have this 7 lines of evidence. That. Any other topic? So, I just want to revise the lamps of evidence. I don't say it is 7 lamps. I say it is just lamps of evidence. Okay. Yes. I have prepared this lecture when we were having in classrooms. And so the classrooms, maybe the second half, they may feel difficulty seeing the slide. We'll explain. No issues. And so coming to the lamps of evidence. What is this lamp actually? Lamp of evidence. Fifth and sixth and seventh rows. I don't hesitate to mark absent for you. I don't hesitate. Remember your witness. Yes. Lamps of diversity. Why is it needed? Is it required for you to know how you should, how you need to develop your profession? Is it required now? Yes. We should have discussed this much earlier actually. Okay? But it's okay. Better late than never. And so what is this actually? Lamps of diversity. You're empty now. You're just empty. You have to develop one skill by the other. You have to inculcate certain attributes of your activity. At least now you should, because this branch of advocacy we are seeing under the subject professional ethics. Much learned to the present day. Sit down. You are a lab. You are just an empty lab. That's all. If you want to flourish in your profession, establish yourself having some ethical content, you need to maintain record, right? Yes. If that is the case, you have to inculcate within yourself, by yourself, whatever you want to get, all the times, so that you can flourish in the profession and you can have a professional advocate, a tag of professional, just an advocate and professional advocate. Advocate is very good. Ll.B. platform తీసుకొని ఎన్నో చేసుకుంటే అయిపోయాయి. But that is not the correct thing. Application possesses certain attributes. For a healthy to maintain healthy relation with the other and see all those things. The first is honesty. Honesty. You must be honest. Honest towards who? Honest towards your client. Your client. We have already seen all the duties, the chapter duties of an advocate towards client, towards bench, towards other colleagues, towards client, opposite party, opponent, opposite client. Okay, opposite client, and when the other one related individual campaign, you should not get an intensity of an advocate. Even if an opposite client comes to you, have a fair discussion. Unless and until you maintain transparency, transparency is more important. You cannot establish yourself. Okay. So the first thing is honesty. You must be honest. You must create an impression in your client's mind that yes, you are an honest person. Your client must feel that yes, this advocate is reliable. We can share anything with him. He is here to save me or protect me, whatever it is. So, honestly, let us say what we do that. First of all, you must be honest. And next, the second jump is strategy. What is the strategy? There are many budding lawyers, budding advocates throughout India who do not have this legal content. No, they fail to observe. Budding lawyers fail because they feel that once they wear the coat, God faces one, bad very type of another. 50% of prostitutes are taking attendance only to show their conduct outside of settlement person. They are navigate and settlement person. There you are lowering the dignity of this profession. Remember, you should be very courageous to take the case. Whatever the case, that is. Next, industry. What is industry? What is the link between this legal profession, advocate, and industry, which you have studied in IT and level of family, you can from the industry here, you can have a symbolic representation. What actually happens in industry? Profession on is not it goes on, a continuous process. As an advocate, you have to put efforts. You have to continuously, you must be thorough with your ethics. Laws will even benefits which really substitute చేస్తున్నారు విషయం ఏమి తెలియకుండా మీరు ఆ విషయం ఇంకోటి చేస్తున్నారో the provision is speaking. If you do not have knowledge of the legal provision and you are quoting the same provision, what happens? So, you must work hard. Okay. So, after getting a professional process, you have to keep aside all the joy, enjoyment, virtual commitment, and things you can manage. You must be, you should have updated information on today's situation, be it political, social, or economic situation. అందరికీ బేస్ ఉన్న కాదు మనం యూజ్ చేయగలం వాళ్ళు మైండ్ బేస్ వేసిస్తారు అది నేర్చుకుంటాం దట్ ఈస్ యూస్ఫుల్ ఫర్ మెంటల్ remember you have to work hard but you have to strive that is why they have represented this outcome as an industry. And next is wit. What is this wit? A sort of humor, sense of humor. When a heated argument or a discussion arises in the court or between advocates, then one advocate should have the sense of humor to lessen the tension that exists in the situation. And another form of that, 5 minutes back I do, no photographs. Then ethical conduct. Like that. Not following the instructions. Amounts to what? Better? Yes. I instructed you. You will listen to the whole class. Twice not taking photographs. In spite of my instruction, you have taken a photograph. It amounts to misconduct. What okay? There we have it. Yeah, sit down. Last letter. Other industry gentlemen, you are a lazy person. You cannot flourish. You take this for granted. You note it down. One day you will remember. Actually, I'm sorry. Next, eloquence. What is this eloquence? Capability. Capable of communicating whatever. Okay. Already you have more code, right? Near future you have more code. Okay, that's the so you remember to maintain all this. You try to follow all these graphs and code. Okay. So what eloquence is? You have better communication skills. You can say not good, better. Doesn't ever because when it comes to communication, uh, earlier version of old version of language, English language and everything. So the traditional language is a systematic way it contains certain rules and regulations. What to follow when to particular thing has to be used every. But with changing times, even the communication skills have changed. And so, best communication development method. Whatever you want to communicate it properly, getting and you should have that talent, which is skill, communication skills are anything. This is the reason why the teachers insist for 5 year students, especially 5 year students. When they take admission to law course, in the first 2 years, they have the subject called English. You have to. At lower level, initially you can read, you can communicate in a regional language, but when you step to a high court, English is mandatory. Your regional language is not permitted. So it is in your hands either limit yourself to lower judiciary or go to the upper standard and regional and better rates and number. Start from now, improve your communication skills. So the advocates choose to have with absence they have excellent communication skills. అలా చూస్తూ ఉండిపోతున్నారు ఏం ఆలోచిస్తున్నారు ఏం మాట్లాడుతున్నారు the words they use make us to wonder which the dictionary refer చేయాలి come to refer the dictionary what is the meaning of particular word what made the advocate use that word in that situation okay you have to improve like learning skills very few old generation we are and have best group of lawyers in the country. We had. And next, judgment. What is this judgment? Judging the situation. You must be in a position to resume or maybe judge. The other advocate will take up this step if an order is passed by the judiciary in this way. At the time of accepting the brief itself, the advocate will have 70% of knowledge whether it wins or lose. So, if the person who lose or win, okay, and the person an advocate has to work hard, has to strive to win the 30% loss also. Next, fellowship. What is this fellowship? It is not like scholarship. Even after enrolling as an advocate, don't expect scholarships. Okay? or other. Okay? So that is what what is this fellowship? Advocate must maintain a cordial relationship with fellow beings who are brotherhood and Buddha over different okay, but once you come out of what you have to maintain the cordial relationship with your colleague and against clients because you are fighting for your life, you are representing your life. So sometimes you may have to behave harshly. It doesn't mean that you are so arrogant or your duty of conduct of good or whatever it is. You are representing your client, you are fighting for justice, you are fighting for your life. And so sometimes you have to, but once you come out of the hall, you have to maintain that cordial relationship. This is what many of you all will see more. And this is the lamps of excellence. And we will be seeing the last lamp, that is fact. What is this fact? That should be a function to deal with the situation. You should have the capability to deal with a situation, a difficult situation, a tough situation. That అన్ని కళల్లో ఇది ఒక అందరికి ప్రాక్టికల్గా డీల్ చేయడం ఓకే పిక్చర్ ఓకే సో దిస్ ఇస్ వాట్ ద ల్యాబ్స్ ఆఫ్ మెటలర్జీ ఇస్ ఓకే దిస్ కుడ్ బైబిల్ అడుగుతా Then, shall I explain tomorrow then? What are the different options available for an applicant? Okay. Master learning today, so even now you can
Where is this? Technical issues. I'll call him.
और उसमें क्या है माउस
Yes, there is class. There is class. Wait. It is afternoon only, sir. तो ये नीचे
मेरे लिए ये वाला अच्छा है
तो यहाँ से आप
So, the previous class we discussed about this sun. Yes. And next topic is Asian. Okay. So, what's the name? It's Association of Southeast Asian Nations. And is an intergovernmental organization comprising 10 countries in Southeast Asia, like Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Philippines, Singapore, Thailand, and Vietnam. Okay. So here the list includes only 10 countries. Now that another country called Timor-Leste was added to the list. Okay, Timor-Leste was added to the list. Yeah. So actually the country is in Southeast Asia, and it was under the control of Indonesia and Portugal for some duration. Yeah. And after it is an independent country now, and it's famous for ordinary family. Okay. So new country that is Timor Leste is being added to the list. Okay, so this association also consists of the new country also. And it is established in August 1967. And the bloc's biggest achievement in recent years has been promoting economic integration among members. So, economic integration is the main objective behind this. So there is economic integration. That can be considered as one of the major objectives behind the formation of such an association. So what is economic integration? Economic integration, we have used this term in different times, different contexts. So economic integration is something like unification of economic policies, okay, among different nations. And what they will do, either they will partially abolish or fully abolish tariff or non-tariff trades. Okay. So that is what economic integration is, means unification of economic policies among different nations. So the biggest achievement we can say is promotion of economic integration among members, and also it is also have to membership the RCEP. RCEP means Regional Comprehensive Economic Partnership. So the world's largest agreement. So the main object behind this is so the RCEP is there. Okay. So it can be regarded as one of the world's what? World's largest free trade agreement. Okay. So the main object behind this RCEP was to engage what? To broaden and to deepen Asian engagement in North America, Australia, China, Korea, and other nations. Okay. That was the main motive behind the formation of this RCEP. Okay. Then ASEAN has struggled to form a cohesive response to Myanmar's military takeover, and China's claims in South China Sea, which overlap with those of several ASEAN members. So we have heard about the military takeover in Myanmar and all. So regarding that issue and the China Sea issue was also we discussed under this agreement. Okay. So what was the problem which had faced in Myanmar? Military takeover. And before that, the Myanmar was a country which was under the British Empire, and it got independent in 1948. And from 1962 to 2011, it was under the control of Indonesia. Then after that, it was by Portugal, I think. And after that, it became democratic. Sorry, the military takeover happened, and now it became resumed as 2021 itself. From that year, we can see the military takeover in Myanmar. Okay, so it is not a democratic country. So the military takeover issues have been happening in Myanmar, the roaming issues and all. So regarding that matter also, this Asia gave some of their opinion regarding this. And also the China Sea dispute, it was a territorial dispute regarding which ASEAN gave, the members of ASEAN gave some responses. But still we can say that they didn't find any absolute solution for those issues, and the Asian members are now willing to disqualify or willing to remove Myanmar from this association, because the Myanmar issue is becoming a global threat to the global security and all. So the members of this association have been planning to remove Myanmar from this association. Okay. So its headquarters is in Jakarta, Indonesia, and the working language is English, and the secretary general is Kao Kim Horn. Okay, and Asians promotes intergovernmental cooperation and facilitating economic, political security, multilateral. Yes, military, educational, and social cultural integration among its members and other countries in Asia. So all these things have been promoted by this association, like what all things it facilitates for economic, then political security, military, then educational and social cultural integration among its members and other countries in Asia. So who are the members comes under this association, all those things have been done between them in order to promote harmony and integrity between the nations. Then, what are the objectives of phase and what is called outcome? Okay. So, the following are some of the objectives of phase, that is to accelerate economic growth. Likewise, every organization and every entity has primary objective, like to promote economic growth, then social progress and cultural development in the region. So, it has been formed in order to promote what? Economic growth, then social progress and cultural development in the region. The region means who are the members of that particular association. So which are the countries? Among those countries, all these things have been encouraged. Then promote regional peace, collaboration, mutual assistance on matters of common interest and all. Then provide assistance to each other in the form of training and research facilities and so on. So if any countries have any kind of training things like that in order to become expert in that particular area, so that concern, who are the members of that particular association, they will grant that type of training and that type of research help to that particular country who are lacking that. Okay. Then comes the outcome. So the Asian Free Trade area, that is African Trade Bloc Agreement, undertakes to support local trade and manufacturing in all Asian countries. So the main function of this agreement is to do what? So what is the main function of outcome? To promote free trade among the countries under the association. So and facilitate economic integration with regional and international allies. So with the help of international help and from regional help, they promote what? They promote economic integration and regional integration. Okay. Then after that is stand as one of the largest and important free trade areas in the world. Okay, free trade area that you know better. Then the outcome agreement was signed in 28 January 1996 in Singapore and comprises all the 10 countries of basis. Now it is 7 countries we already discussed here. So what's the primary goal? What primary goals can be set under this outcome? So that is to increase Asia's competitive edge as a production base in the world market through the elimination of tariff and non-tariff barriers to bring these. That means the trade barriers. They are planning to remove, or they had been discussing, or they have the opinion to remove the trade barriers which are in existence in trading area. Okay, so that should be removed. So that is the primary goal of this outcome, and attract more foreign direct investment to Asia. So in order to maintain their economic growth, they are encouraging for foreign investments and all. So these are the, you can say that some of these are the goals set by outcome. Then comes the European Union, EU. Okay, so the European Union or EU is the unified political and economic body of 27 member states that are located primarily in Europe. So it consists of how many countries? 27 countries. Okay, so there are total 27 members under the EU. And the EU has often been described as a state-level political entity, combining the characteristics of both federation and confederation. State-level means of its own kind is nothing like. It's the same thing like nothing can be made as it is. Okay. So we can say that it is a combination of both federation and confederation. So what do you mean by federation and confederation? Federation, federal government is there. Yes. Yeah. So here in confederation, what happens is that the federal government is giving importance to the states. Okay. So they are giving some care to the states as well. But here in federation, what happens is that the federal government is ultimate power. Okay. So in confederation, the federal government is answerable to the states. But here in federal government, what happens is that the government itself is the primary or ultimate source. Okay. So we can see here under the European Union there is a combination of federation and confederation. Okay. So this type of partition of powers we can see inside this European Union. Then the capital is in Brussels and it eliminates all border controls between members so that free flow of goods and people except for random spots for crime and drugs. So here it encourages for free trade. Okay, so there will be no tariff and there will be no duty imposed on the products if anything has been traded between these countries and except for random spots for crime and drugs. So if in case it arises any kind of crime or any matter in concern with drugs and all, at that time also there is a need to check all those things, otherwise they have been given everything free, like everything there is the transparency has been maintained. Okay, so they are free to trade goods and services. And it is the only regional body that has its own legislature known as the European Parliament. So they have a specific legislature known as what? European Parliament. They have a special law which is called the European Parliament. Then it has the high, so let me say, so high human development index. So the EU have the high human development index. It's HDI we call it. This is statistical composite index for measuring that education level and what do you say, the income indicators and all. So it's high in EU and through the common foreign and security policy, the EU has developed their own external relations and defense. So they have been emerging as a superpower, like they have been given the security policies there and they have been given an important role in the external relations and defense as well. So due to its global influence, the EU has been described as an emerging superpower. So we can now say that the EU has been emerged as one of the superpower. Okay. Then any product manufactured in one EU country can be sold to any other member without tariffs or duty. It has already been mentioned that among the nation and among the member states, there is a free trade of goods and services being provided. So here we can also see that EU countries also given or free trade area is there and they are also giving products without any kind of tariff or there is no trade barrier in it. So there is no existence of trade barrier in this area. Then when coming to the objectives, we can say that the European Union is to promote peace, follow the EU's value, and improve the well-being of nations. So its primary object or primary goal is to set out what to promote peace, international peace, then to follow the EU values and improve the well-being of nations. So not only take care. So then we already discussed that, we already said that how many members are inside the EU. How many members are there? 27 members. So the main function of this EU is to maintain peace and harmony between these 27 nations or 27 member states and to look after and improve the well-being of this 27 nations. And for that, they have set up some kind of objectives or some kind of goals. And these are to create a free and safe Europe with no internal borders. So there is no internal borders. Okay, there is no internal borders in the sense free trade is there and there is no imposition of tax, tariff in the case of doing trade. Okay, and while transferring any goods and services, no tax or no duties have been imposed. Okay. So it is there, so there is no internal borders between the member states and ensures smooth and efficient trade, that is transparency is there and the trade is fair. Then promote free and fair competition between the companies. So among the nation, so which are the companies they are providing some competition. Okay, so that the concerned nation can provide good products. Okay, so they are creating a kind of competitiveness among the members so that they can improve the products as well. Okay. They ensure use of sustainable and steady development through balanced social economic growth and stable prices of essentials. So they are doing another thing, that is they are maintaining stable prices of essentials. So what do you mean by price stabilization? Have you ever heard? There is no fluctuation. It is stable. Yes, if you so the price won't get high. Okay, so that stability and the stability has been given for essential products. So that is the basic products which are needed for the citizens or the people over there. What they will do is that the price will be the same. It will be a stable. As compared what we can say that it provides some kind of visibility, quality, and kind of what we can say. The purchasing capacity or the national currency can be protected. Okay. And if the stability of the prices has been maintained, the people can be have a better option, or the people can be the good consumers of the products and all. And if the price is stable, there will be more use of the products and all, and that way we can improve the economy. Okay. And we can improve the economy, and also we can improve the employment opportunities as well. Okay. So that is the one of the main benefit of price stabilization. So by maintaining price stabilization, we can improve the economy and also the environment as well. Okay. So it is also one of the primary objectives of what they are discussing about which topic EU. Yeah. Then protect the environment and prepare any environmental damages. So they are also giving some kind of importance to the environment also. Okay. So like sustainable development, they are giving more important, and likewise to the improvement of environment also. They are giving some kind of initiatives. Okay. They are protecting the environment by the implementation of certain provisions and all. So all these are, we can say, the some of the objectives set by EU. Okay, or we can say that these are the primary goals of EU. Then coming to NAFTA. So what's the full form definition of NAFTA? NAFTA. Yes. That is North American Free Trade Agreement. Okay. And it was signed between USA and Canada in 1988 and enlarged by inclusion of Mexico in 1994. NAFTA. So, the former US President, please listen. So, regarding NAFTA, the former US President Ronald Reagan, he was a person who came with the concept of free trade in North America. Okay, and he put that concept during his presidential campaign and all that in 1989. Okay, so after that, the NAFTA came after his initiation and all, and Mexico, Canada, and US were the parties. And it was signed by the US, Canada, and Mexico in 1993 and went into effect on January 1994. Then eliminated all tariffs for products moving among three countries and other barriers to service and investment capital within North America. So here the preference has been given to the three countries because three countries are the parties, and based on these three countries the agreement has been formed. So that is NAFTA. So areas of NAFTA, that is market access, trade through services, investment, intellectual property, dispute and settlement. So all these are the areas which comes under the NAFTA. So these areas are any concern relating to this area have been discussed and have been solved under what? Solved under NAFTA. So the NAFTA is a comprehensive trade agreement that sets the rules investment in Canada, the US, and Mexico. And the NAFTA has systematically eliminated most tariff and non-tariff barriers to free trade and investment between the three NAFTA countries. So which are the three NAFTA countries? US, Canada, Mexico. So it was established in 1994 and the official language is English, French, and Spanish. And Secretary Mexico, Ottawa, Washington DC. So the NAFTA subject next. So which are the outcome of this NAFTA? What are the outcome of NAFTA? So here we can see nine. There is the North American Agreement on Environment and Environmental Cooperation, and now there is the North American Agreement on Labor Cooperation. So they are giving importance to what? Environment and also to the labor. Okay. So for that they had formed another agreement like this, NARC and NIAC. Then what actually does NAFTA do? So it allows free movement of goods and services between US, Canada, and Mexico. That is free trade. Okay. And provides competition in the free trade areas. And if they are providing free trade area, then they are also creating what? Competitiveness. Okay. And increases investment opportunities for member countries. So they are also providing what? Employment opportunities as well. Okay. And also more participation in trade. Then protects the property rights of people and business in the community and solves problems that arise between the member countries. So here also we can see that there is a kind of mechanism where if any dispute arises, the same thing can be resolved under this area. Okay, so they will solve the problem which arises between the member countries and encourages cooperation between the member countries and fostering multilateral and regional ties to increase the benefit of trade. What is trilateral trade? Yeah. Yes. So there are some kind of treaties in order to boost or in order to foster what the benefit of trade. Then increasing changes for foreign investment within the nation, so they are also encouraging foreign investment and all. And in September 2018, the US, Mexico, and Canada reached an agreement to replace NAFTA with the US Mexico Agreement USMCA, and all the countries had ratified by March 2020. And this USMCA came into force on 1st July 2020. So what happened is that this NAFTA agreement has certain provisions like for environment, then employment and economic growth. And some of the analysts have the view that it giving much importance to the North America and also to the average citizens of that particular area. And the most affected persons were the farmers or the minority workers who were employed in the industry. Okay. So the NAFTA had this kind of drawbacks and all. So finally what happened was that later in 2017, the term of Donald Trump, he was of the opinion that he sought to remove NAFTA, and for that he began to form negotiation between Canada and Mexico, and they came with another concept called this UNCA. That is, they form another agreement with the help of United Nations, then Mexico and Canada, and they form another agreement called UNCA. Okay. So, the NAFTA also aims to safeguard intellectual property rights for traded goods. So, the NAFTA also serves like it also protect the IP of all traded goods. Okay, so the provisions regarding the protection of IP was also be provided under NAFTA. So, the provision of NAFTA we can see is the elimination of trade barriers. So, here in NAFTA and also in NAFTA and ASEAN also we can see the same provision like the removal of what trade barriers, okay, or trade restrictions have been removed. So elimination of trade barriers is there the intellectual property protection again it speaks about the IP protection and all. Then environment and labor protection is there and dispute resolution. Okay, so here it has a place for dispute resolution and all. Okay, so if any dispute happens between the US, Mexico, and Canada relating to trade or any other matter, the same thing can be resolved and the decision can be made under this platform. Okay. So the USMCA, which substituted NAFTA, is a mutually beneficial win for North American workers, farmers, ranchers, and businesses. So that's the NAFTA was replaced by why NAFTA was replaced by USMCA. Why? Why it was replaced? Because NAFTA already contained what provisions for the environment, then economic growth, and all. These areas are always the base of political dispute now. So what happened was that some of them were of the view that it has been less importance to the minority, okay, or the minority farmers we can say, the minority workers we can say. So by removing this NAFTA, what the next thing was USMCA. So it gave importance to what are these to the North American workers, farmers, then ranchers. Ranchers means ranch means some like large farm where animals or cattle are kept. Okay. So it gives benefit or it provides help for the ranchers and businesses. The agreement creates more balanced reciprocal trade supporting high-paying jobs for Americans and growth in North American economy. So it was like it had treated every area same. Okay. So no partiality or no bias has been created. So it was formed in order to create a kind of harmony between all groups of the society. So that was the main reason why the NAFTA was replaced and USMCA gained the power or gained the full attention. So it was very much beneficial for the Americans and also for the North American economy as well. And the provisions regarding the NAFTA are dairy and agriculture. That is, they are giving more importance for dairy and agriculture and all their encouraging agriculture and their encouraging dairy products and all. And automobiles, provisions for automobile manufacturing and all, then intellectual property, then sunset provisions and labor. So, sunset provisions, no, never heard. So there are some measures we can say in the law or regulation and act. Okay, this is something like that law will cease into effect after a certain date, certain measures are taken. So after this date, this particular law will become inoperative unless it has been extended by a legislative power. So that measure is called as sunset provision. Okay. So if there is no legislative power has been there, then it will continue. Otherwise, it will come to stop after a specific date. Okay. That is called as sunset provision. And then the next one is labor. So they are giving more importance to what labor and all. So here the provisions we can see they are giving importance to dairy, automobile, cycling, sunset and labor. So they are treating the society equally. They are giving chances for each and every sections of the society. And that was the main achievement of this what NAFTA. Yeah. Yes, USMC. Okay. That's all. Anyhow, so what is the difference between NAFTA and USMCA? Is there any kind of difference? And regarding ACI, so this deals with North America and all, and why does that's a Asian difference? Southeast Asia. Yes. That's the yeah, right. So we can say that the free trade area and the regulation, or we can say that the restriction on the tariff and non-tariff, it has been given importance in all these areas. Okay, so the removal has been there, like they are giving much priority to all these things. That means, anyways, they are encouraging for trade. Okay. Yes. Right now, starting with this topic. Conventions are there. And you can see that if it is the turn after or if it is provision from what? Provision under WTO. Okay. And the US sector. So this model has already been there from where all the provision has been taken and the association is there, but the provision has been implemented under this organization so that they can use the thing and they can do the trade and all without any kind of what? Any kind of restrictions at all. Okay, for that purpose, they have created the free trade area and the non-tariff and all. So in every provision, we can see all the things. Yes. Because it depends, like you know that every country has their own legislation. Okay, so it is not at all possible for them to implement the whether it will give a protection to the next country. That's easy. Objective is it. One thing has been said, there is general provisions they will adopt and they will implement it into their law and make it more liberal to the people who are the citizens of that particular area. Okay, so it is not at all possible to implement the whole idea. They will take certain provisions and they will mold it into their own convenience and they can do the what we call the trade and all. So it is not possible to do the same like which has been provided under the convention and all. Because the convention also says that they can use the provisions under the convention and they can mold it under their domestic laws. Okay. Sorry. Yeah, it's a kind of globalization, sure. So we can say separate associations are there. Okay. So in one way or another way, that will be the same thing. That will be done now. No. So it's a part of globalization. Okay. So what is your concern with regards to globalization? Yeah, it is there. Yeah. So it is. Yes. It can be already possible. It can be possible already by the implement such things. Okay. It is not possible to rule the entire world with one law. It is not possible. Yes, it's there, but we are not adopting every provision which has been given under the WTO. We are taking some of the provisions and we are modeling it under our rules and we are implementing it. So that can be done. So every country is doing things for their benefit, for their economic development. Yeah. Yes, they're already taking develop trade. So without the help of a country, how a country can develop their trade? So for that, they need some other, yeah, other associations, but yeah, other development, yeah, but they will have a kind of association for that. Yes, if we study it deeper, then we will come across the other organizations as well. You can't say that there is no association or there is no union for the underdeveloped countries. Sorry. If you study, if you go to that, then you can come across with many other conventions and many other agreements and many other organizations as well. So you see all those things definitely. So if you study all the things then you can't conclude into all the things that doesn't really happen around nations. Okay. So that's what I'm saying. They have a kind of association and they will use that thing for their development. Now we are not studying the thing. And you don't know that for Africa, many health and medical facilities have been provided under the UN. The UN is helping very much in African countries. They are promoting their what we say education. But they think that African countries we cannot trade. No, we can work with African countries there. But it is not important in our at least marks, get pass marks. Because I was saying that 70% of the people taking this subject. I don't know. I don't know. So it's all about my hard work. So don't make me feel ashamed, okay? Yeah.
Time notified.
So participants of the football competition. Tomorrow there is a meeting regarding the football and tomorrow. So try to be there. Those who are registered themselves for the competition, try to be there, or at least one member from the team. If you know about that. And the time of the meeting will be notified tomorrow morning. But the time of the meeting will be notified tomorrow morning, so don't worry about that one. At least one member of your team should be there. Or if you don't know about your team, we try to present there those who are registered themselves, and you register those who are to please be there. Sir, you also. And right now, this first girls, 5 years, go to your respective classes.